Good morning, everybody. My name is Mariana Mitchum. I'm with the Bureau of Alcohol, Tobacco, and Firearms. Thank you all so much for taking time out of your schedule to attend this training today. I want to point out a couple of quick things before we jump into it. First and foremost, the PowerPoint that we are going to go over with you all today is posted on our website. So if you go to atf.gov, you can click on the Firearms page, find it there, or you can simply go to the search bar and type in factoring criteria for firearms with attached stabilized braces. It will bring you to a page with all of the publicly posted information on this final rule. There are frequently asked questions on there, as well as some helpful guidance documents dealing with particular firearms that fall under this category. During the training today, we will not have the ability to allow participants to verbally ask questions. That's simply because as of right now, there's nearly 1,200 participants on here, so all of us opening our mic at the same time would not work very well. So instead, you can go ahead and drop your questions in the chat. We will answer your questions at the end of the PowerPoint. Obviously, we will try and get to as many questions as we possibly can. Our cutoff time today with the training is at 11:30. We will have 3 more trainings after this one. We will have a training at 2 p.m. and then tomorrow at 10 a.m. and 2 p.m. as well. All right, let's go ahead and get started.
So to provide a little background, we're going to discuss how we got to where we are today. So on November 8th of 2012, NFFL submitted the first stabilizing brace prototype to ATF, which was a brace that attached to a heavy AR-type pistol. The brace would rest on the forearm and could be fastened with a strap. According to the submitter, the purpose of the brace at the time was to provide security for disabled shooters or anyone who did not have the physical strength to accurately shoot a heavy pistol. The submission was to get a determination as to whether the device, when attached to a firearm, would not change that firearm's classification from pistol to something else under the federal law. Based on the information provided, ATF inspected the brace device and found that that particular prototype, when attached to a firearm, did not result in a firearm designed or intended to be fired from the shoulder. Well, since that time, the firearms industry has been flooded with so-called stabilizing braces that no longer resemble the original prototype, and most of them have been marketed and sold as shouldering devices when attached to a firearm. So the entire background can be found in section 2B of the preamble of the final rule. So then the next slide shows the original submission back in 2012. And as you can see, what the original prototype looked like, and when attached to the person's forearm, it clearly provided stability for shooting. Next slide. So summary of change. The final rule's amended definition of the term rifle now provides that a weapon equipped with an accessory, component, or other rearward attachment giving surface area for shouldering the weapon will generally meet the definition of a rifle. There are other relevant factors in the final rule that must be considered. The intent of the final rule is to clarify that firearms with attachments that provide surface area for shouldering indicates that it is indeed designed, made, and intended to be fired from the shoulder. The final rule was signed by the Attorney General on January 13th of 2023. It was published in the Federal Register today, January 31st, which starts a 120-day countdown for all compliance obligations set forth in the final rule. The deadline to comply with the final rule's statutory requirements is May 31st of 2023. So what are the implications of the final rule and the amended definition of a rifle now that it includes stabilizing braces? Well, this means that all previous classifications are superseded and considered null and void as of today's date. Firearms with such attachments may be submitted to ATF for reclassification, which we'll get into later in this presentation. There are other alternatives available for anyone who does not wish to go through the NFA registration process, as we'll get into later in this PowerPoint.
All right, so bear with us. We've got a lot of words on the next couple slides, and then we'll get into a lot of photo examples of what we're talking about. So the final rule amended the regulatory definition of rifle. And now both 27 CFR 478.11 and 27 CFR 479.11 define the term rifle as, for purposes of this definition, the term designed or redesigned, made or remade, and intended to be fired from the shoulder shall include a weapon that is equipped with an accessory, component, or other rearward attachment, e.g. a stabilizing brace, that provides surface area that allows the weapon to be fired from the shoulder, provided other factors, as described in paragraph 2, indicate that the weapon is designed, made, and intended to be fired from the shoulder. When a weapon provides surface area that allows the weapon to be fired from the shoulder, the following factors shall be considered in determining whether the weapon is designed, made, and intended to be fired from the shoulder. 1, whether the weapon has a weight or length consistent with the weight or length of similarly designed rifles. 2, whether the weapon has a length of pull measured from the center of the trigger to the center of the shoulder stock or other rearward accessory, component, or attachment, including an adjustable or telescoping attachment with the ability to lock into various positions along the buffer tube, receiver extension, or other attachment method that is consistent with similarly designed rifles. 3, whether the weapon is equipped with sights or a scope with eye relief that is required the weapon to be fired from the shoulder in order to be used as designed. 4, whether the surface area that allows the weapon to be fired from the shoulder is created by a buffer tube, receiver extension, or any other accessory, component, or other rearward attachment that is necessary for the cycle of operations. 5, the manufacturer's direct and indirect marketing and promotional materials indicating the intended use of the weapon. And 6, information demonstrating the likely use of the weapon in a general community. So the first one in the initial paragraph is surface area. And that's when a weapon provides surface area that allows the weapon to be fired from the shoulder. As you can see, basically every stabilizing brace marketed today has some amount of rear surface area that allows the weapon to be fired from the shoulder. Next slide. Weight or length. Whether the weapon has a weight or length consistent with the weight or length of similarly designed rifles. So basically, we're going to do an apple-to-apple comparison, not an apple-to-orange comparison, and compare the weapon with the stabilizing brace or other accessory to a similar designed weapon. Next slide. Here's an example of that where the top weapon has a stabilizing brace attached and was marketed and sold as a pistol, where the weapon below it was marketed and sold as a short barrel rifle. Next slide, please. And here's a few other examples. One of another AR type platform that had both a pistol and a short barrel rifle marketed and sold. And the ones on the right are a chassis for a Glock type pistol or other standard size handgun that are both known to both sell SBRs and chassis with stabilizing braces. Next slide, please. Length of pull. So length of pull is a common measurement of firearms that describes the distance between the trigger and the center of the shoulder stock. A shoulder-fired weapon generally will have a length of pull that allows the placement of the firearm's shouldering device against the shooter's shoulder while also ergonomically allowing the shooter to engage the firearm's trigger. Adjustable or telescoping attachments that lock into place provide horizontal support for firing from the shoulder.
Look at the TV. Oh, I saw that. Oh, yeah. I let Tanya,
Hey, can you mute your microphone?
Next slide, please. So here's an example of how we measure length of pull. The stabilizing brace or other attachment will be extended into its rearmost lock position, and the measurement will be taken from the center of the trigger to the center of the shouldering stock or shouldering device. Next slide. Sights or scopes that cannot be used without shouldering the weapon indicates the weapon is designed and intended to be fired from the shoulder. Next slide. And here's a very blatant example of that, where that scope can only be used because of its reticle when the shooter's eye is placed within 3 to 4 inches from the rear, basically making the weapon need to be fired from the shoulder. Next slide. And here's a few other examples, one being a scope like in the previous slide. The one on the right is a magnifier with a reflex or red dot optical. A reflex or red dot would not qualify, but the presence of the magnifier in that instance requires the shooter to place their eye close to the sight. And on the bottom, we have an extreme example of a thermal type sight where, again, the shooter must place their eye very close to the sight. Next slide. Rearward attachment. What we mean here, an AR type pistol with a standard 6 to 6.5 inch buffer tube may not be designed and intended to be fired from the shoulder, even if the buffer tube provides surface area that allows the firearm to be shoulder fired, because it is required for the cycle of operations. Yes, AR buffer tubes, whether we're talking M4 or round pistol, provide some rear surface area. However, they are necessary for the cycle of operation, as we'll see in the next slide. And I'm sure everybody pretty much on this call understands how an AR works and how the buffer and a buffer spring goes back into that buffer tube or receiver extension, allowing the weapon to cycle. Therefore, that's a necessary component of the firearm as a whole. Next slide. Here's some examples of firearms that do not need that rearward attachment. On the top, we have an AK type firearm. On the bottom, we have an HK type firearm. Neither need a rearward attachment in order to complete the cycle of operations. Next slide. So the manufacturer's marketing and promotional materials for a weapon are relevant in considering the likely use of the firearms in the general community. So here we're taking in both stated intent and also how these weapons are being advertised for use. Next slide. And finally, we're going to look at general use of the weapon in the community. I think it's pretty known that there's a lot of advertising of these weapons to be used as shoulder-fired weapons. Ending it off.
Good morning. The affected parties are your unlicensed possessors, which are your individuals, your federal firearms licensees that are not qualified as manufacturers or importers under the NFA. You have your FFL importers and manufacturers that aren't qualified under the NFA, and you have certain government entities. This is a tax forbearance. So persons who are currently in possession of these firearms currently will not be required to pay the tax. Individuals, FFLs and FFL SOT dealers will not be required to pay the $200 making tax. However, they will need to submit an ATF E-Form 1 starting today through May 31st of 2023. FFLs and importers who are qualified under the NFA, they will submit for SBRs that are in inventory with a stabilizing brace on them, the E-Form 2 by May 31st, 2023. The E-Form 2 is not a tax paid form. It is a notification. So there was no tax change there. And once it is registered in the NFRTR, all applicable transfers are taxed. Options for possessors. Possessors can remove short barrel and attach a 16-inch barrel. What we have to remember is it still must meet the 26-inch overall length for a rifle under the Gun Control Act. They may also permanently remove and dispose of the brace. They can turn their firearm into their local ATF office. They can destroy the firearm or register the weapon as set forth below, depending on the category of possessor that you fall under. Registration options for non-licensees, again, this is your individuals that currently possess these things. They have until May 31st, 2023 to register the device that they currently possess as of today. So they must be in possession of it as of today. They have until the 31st to do an E-Form 1. They will not be required to pay the $200 making tax. They can adopt all markings that are on the firearm. And if the firearm is not marked, they must comply with 478.92 and 479.102. For FFLs that are, for FFLs that are not manufacturers or importers under the NFA, they actually have the same options as an individual. They can complete the ATF E-Form 1 up until May 31st, 2023 for all SBRs that they possess today with a stabilizing brace on them. They will not be required to pay the $200 making tax. They may adopt the markings on the firearm. And if the firearm is not marked, they will have to comply with 478.92 and 479.102. FFLs that are not importers or manufacturers under the NFA. If you do not pay a special occupational tax as a dealer, you will not be allowed to continue to deal in NFA firearms. So if you want to continue to engage in the business of dealing, you must pay the special occupational tax as a dealer. If you want to continue to manufacture these SBRs with these devices, you would need to pay the special occupational tax as a manufacturer under the NFA. Importers and manufacturers that are qualified under the NFA, they will submit the Form 2 for all devices with, or SBRs with the devices that they have in inventory as of today. They will have until May 31st to submit the Form 2. And to transfer after today, the SBR must be registered in the NFRTR, and further transfers would be on a Form 3 or a Form 4. Government entities have the option to use the Form 10, but the transfer after it is registered in the NFRTR is limited to other government entities. They also have the option to do the E-Form 1 for all firearms that they have in their possession. They have until May 31st to do that, and it will be tax exempt. To transfer a firearm after January 31st, 2023, the firearm must be registered in the NFRTR and a Form 4 must be submitted and approved for transfer to an individual. SBRs with stabilizing braces that are made after today's date will be required to submit an NFA Form 1, and they will be required to pay the $200 making tax because they are making it after today or today forward. These are our resources. If you go to the first link, that will take you to how we got to where we are. It will have the PowerPoint presentation and we will have Q&As. Then we have the E-regs. We have the E-form process if you go to the third link. And then the fourth one is if you need to become an FFL SOT licensee. If you want to send your questions in, you can, if it's a general question, you can send those to fipd@atf.gov. If you have a technical question regarding a determination, you will need to send that to the Firearms and Ammunition Technology Division, which is the fire_tech. If you have a question about the rulemaking process, that is ORA. And if you have any questions on the E-forms for NFA, either accessing it or how it's to be done, you can go to the Ask the Expert under the NFA tabs.
All right, now we are going to go over some of the questions that were dropped into the chat. Real quick, just a few that were in there several times, asking about the link for the the stabilizing brace, we will drop that in the chat in just a minute. Austin, if you can go ahead and drop that in there, the link to the PowerPoint that we just went over, right there, that's that very first link. We will send that out to everyone in the chat. The other question we got was the additional 3 trainings that are coming up again today at 2 o'clock Eastern, and then tomorrow at 10 a.m. Eastern and 2 p.m. Eastern. It is the exact same training that we're doing today. So you are obviously welcome to attend again if you would like, but yes, it is the exact same training. All right, so the questions. First question, will this rule reclassify items like the Mossberg shockwave? I'm referencing the letter Mossberg received dated March 2nd, 2017.
Yeah, I got this one. So the Mossberg Shockwave was approved without any rearward attachment. It is still a GCA firearm. It doesn't have any rearward attachment that would fall under the purview of this final rule.
Excellent, thank you. Next question. When customers complete the Form 1 process for conversion to a SPR, is engraving of their name/trust required as it was before?
No, under this final rule, they are allowed to adopt the markings on the firearm unless the firearm is not marked. They will have to comply with 479-102. But if it has markings, they can adopt those markings.
Great, thank you. The next question, to manufacture a SPR under a trust through this ruling, pistol owned by the trust, what proof is needed to do so? So I think the question is, what proof does the individual need that the firearm was owned by the trust?
Typically, a trust document that shows the property that's currently being held by the trust, I think normally it's a Schedule A. So they would need to show the Schedule A that's dated prior to the effective rule of the trust, showing that that is trust property.
Okay, the next question. Will there be a time frame by which the Form 1s will be processed, and will their processing affect the timelines on existing electronic Form 4s?
We have not established a processing point until we find out how many applications, incoming applications we receive.
Okay. For Type 2 pawnbroker FFLs with current pistols on loan that have a stabilizing brace, what condition should we return the pistol upon the customer redeeming their loan? So this is obviously talking about pawn shops that have these in inventory, pistols with attached stabilizing braces that now are considered SBRs. What is the pawn shop's options? So if you are a pawn shop and you are currently in possession of one of these items, the rule is now effective. It was published today in the Federal Register. So the item cannot be returned to the customer in its current configuration because that would be the transfer of an unregistered SBR. So your options are just like all the options we went over just a minute ago as an FFL. You can remove the brace. You can add a 16-inch or longer rifled barrel to the firearm. You can turn the firearm in. You can destroy the firearm, or obviously you can register it. So being a pawn shop, at this point, you certainly want to contact the customer and work with the customer on returning it to them in the configuration that they are okay with. But the bottom line is you cannot return it as its current configuration because that would be the transfer of an unregistered SBR. All right, next question. If the brace is removed from a pistol, does a standard buffer tube need to be changed to a featureless pistol buffer tube?
No, we're saying that's not going to be the surface area there. We are stating that that is needed for the cycle of operation and it is not down to solely a pistol buffer tube.
After the 120-day grace period, what is to be done with the firearm if you are still waiting on the tax stamp? Is the firearm to be disassembled, or can it be used till approval or denial is issued?
No, we make it clear that what you should do is maintain proof of submission of either the e-form or the paper. I'm hoping it's just the e-form. And as long as you maintain possession of that, you'll be in compliance while you're waiting for your application to be processed.
All right, next question. Are firearms without stabilizing braces impacted? Meaning, if a large pistol has the ability to attach a stabilizing brace to it, buffer tube, 1913 rail, etc., but there is no brace attached, is this type of firearm considered a pistol or unregistered SBR?
Based on that information, we couldn't necessarily say it's a pistol by itself, but it would not be considered an SBR unless it first had some sort of rear surface area as laid out in the final rule. But it could still fall into the other or the firearm category, so we can't necessarily say it's a pistol based on that information.
Okay, next question. How do residents of California comply with the NFA registration process?
Typically, there are a couple of states out there who are not going to allow for the possession of a SBR, whether or not it's registered. In those situations, the NFA branch should be unable to approve that. We cannot approve an application for an SBR if it would put the person in violation of state law. So in those situations, the person who is currently possessing it would have to dispose of it in compliance with state law. There are other options, of course, that are available that you saw on these slides, just other options that are available to you. Registering it may not be possible because of your state laws.
Okay, next question. What about someone who has purchased an AR pistol with a pistol brace that is on a 3-day wait to pick up, but purchased a firearm before January 31st, 2023? What options does that person/FFL have? So it's whoever is currently in possession of it. So unfortunately, in that situation, again, like I talked about with the pawn shop, if the FFL is still in possession of it, they cannot transfer that firearm in that current configuration because that would be considered the transfer of an unregistered NFA weapon. So again, we go back to the options for FFLs and unlicensed persons. Again, that FFL has the option to remove the brace and transfer the firearm as a pistol, to add a 16-inch rifled barrel and transfer it as a rifle, or destroy the firearm, turn the firearm into ATF, or register the firearm. So again, it's whoever is in possession of it as of today, the effective date of the rule. All right, next question. Will the ATF be able to process all Form 1 stamps in 120 days?
We will do our best.
And can you talk about, as long as they've sent in, they've applied, they've done the E-Form 1, it just hasn't been approved yet?
They can just keep a copy of their submitted application as proof that they have submitted the registration.
So the key is to have the E-Form 1 or E-Form 2, depending on who you are, submitted within the 120 days. It does not have to be approved in order for the individual to be in compliance.
Yes.
Correct? All right, next question. Is it allowable to attach a stabilizing brace to a standard non-NFA rifle?
Yes, it's an accessory by itself, and if you have a 16-inch, that's one of the options. If you have a 16-inch non-NFA barrel length rifle, then yes, you could attach a stabilizing brace to it.
Okay, next question. Does this apply to pistol caliber AR pistols? And the person wrote, so 9mm, etc.
Yeah, it applies to any firearm that has the rearward attachment or surface area.
Okay, next question. If a person owns an AR-15 style lower receiver with an attached stabilizing brace and multiple short-barreled uppers, like one in 5.56 and one in 300 blackout, what would be the proper process for the registration?
You register the firearm, and what you put on it on your application on your Form 1 is the caliber that's on it. So if you have it like 223, you put in there that the caliber is 223. But I believe in the comments you put that there's multiple calibers associated with it. So you can swap out your uppers on the registered firearm, because remember the receiver of the AR, the lower, commonly referred to as a lower receiver, is the registered portion of that. You can still swap out calibers on that without needing to register additional firearms.
Okay, we have some more questions on the rear surface area. The individual asked, if I'm hearing this correctly, any amount of rear surface area would mean that the brace is now classified as a stock.
If it would provide rear surface area and also meet one of the other criteria that was also named throughout it.
Okay, next question. I submitted 2 firearms about 3 years ago for classification, but have not received any direct communication from ATF regarding a decision. I saw one of the firearms depicted on the ATF website as being considered an SBR. Can I file Form 2s for those 2 firearms so they can be returned? If so, what date of manufacture should I use? And would I need to provide anything other than the approved forms and new shipping labels in order to get the firearms returned?
You can write into Fire Tech if you'd like them returned immediately. We are in the process of completing the evaluation and the official classification. But if you've seen yours used as part of the initial ATF guidance, you probably know which way we are leaning. But yeah, if you email Fire Tech and you want them returned immediately, we can get them right back to you so you can start the process whichever way, whichever option you want to use. I will defer what the date of manufacture is to.
So they use the original date of manufacturing, so that's what's in your A&D books. And then you would attach, if you are submitting via e-forms, you would attach a letter that states the reason why there's such a length in the delay between the day that it was actually manufactured and the date that you're submitting the form to.
Perfect, thank you. Austin, can you put up the next slide on the PowerPoint that has the email addresses on there? There you go. There's the Fire Tech. I know it's a little bit hard to see on there. It's fire_tech@atf.gov. All right, next question. When is the ATF going to quantify the surface area, length of pull, etc., allowed for pistols not to be considered SBRs?
So there is no quantifiable amount. The way the rule is read is that it provides sufficient surface area to allow for shouldering. It would just be a reasonable standard that's applied by courts every day. As far as length of pull, as we said, we're not going to give you a specific length of pull because we're comparing apples to apples. You're going to have a different length of pull for an AR versus an HK, like an MP5 is going to be different, or even an AK. You're going to have different lengths of pull. So we're going to compare it sort of apples to apples, oranges to oranges. There wasn't a necessity to give you 6 inches, 12 inches, 9 inches, 13 inches.
The final rule also provided some charts, not just for length of pull, but also for weight and lengths of common known rifles.
And again, just like I said, this PowerPoint is available on our website. The final rule regulatory text is on there as well, so you can go in. This obviously is a very abbreviated PowerPoint. The final rule, I think, is 98 pages, so you can go in and read all of that. All right, next question. So are we saying that a red dot, such as a Holosun, EOTech, etc., with a magnifier does not qualify for this because it is a quick acquisition optical? I just want to be sure.
Correct. A lot of the red dots, reflex or holographic sights are what they call unlimited eye relief. So they're common use on standard pistols and other pistols, and they do not require or indicate the shooter is going to fire the weapon from the shoulder. So that is correct.
Okay, next question. How does a FFL retailer proceed when an unregistered SBR arrives at our premises without a Form 3?
Not a Form 3. Contact the FFL that sent it to them to see if they did the proper paperwork prior to sending it to the FFL that received it. And then I would say contact your local ATF office, because if the transfer was done unlawfully, we would need someone to come out and take possession of it.
You would handle this the way you would handle any NFA firearm that was mailed to your place of business that you opened up. We're not expecting, and there's no paperwork with it. You would just handle it the exact same way. These are essentially short barrel rifles that would be sent to you without any paperwork.
Thank you. Okay, next question. What do we do if we have a pistol braced firearm in the gunsmithing department? How do we transfer back to the owner? So again, this is similar to the other FFL questions we've gotten about having these items in your inventory, in your possession. It doesn't matter the reasons why you currently have it, if it's there for pawn, if it's there for gunsmithing, if it was just shipped to you. The bottom line is you are the current possessor of that item. So again, you have those 5 options we talked about before. Remove the stabilizing brace, attach a 16-inch rifled barrel. You can destroy the firearm, you can turn it in, or you can register it. You can register it with the E-Form 1. If you are an FFL that does not have a manufacturer or importer SOT, if you are an FFL with a manufacturer or importer SOT, you could register it on an E-Form 2. Next question, what happens to those Form 1 submissions that are not processed by May 31st, but were submitted on time? Again, we had this question a minute ago. As long as you submit your E-Form 1 or your E-Form 2, depending on who you are, as long as you submit that prior to May 31st, retain documentation that you submitted it, you are fine. You are in compliance. As we've said at the beginning, it may take longer to get these items all processed, but the compliance part of it for you as the possessor is to submit the documentation. Next question, how does the ATF expect to approve all Form 1s within the 88-day delayed timeframe before returning Form 1 as disapproved due to inactivity?
We are currently working with the FBI on anyone that's in an open status. There's some misinformation floating around out on some of the blogs that is not accurate. There's more to come on this subject. Again, we are collectively working with our FBI for a path forward for folks that remain in an open delayed status.
Okay. Next question, just to be clear, removing of any stabilizing brace would render the firearm compliant with the new classification?
In general, yes. I'm sure there may be a scenario where rear surface area remains after the removal of the firearm. But yes, removing the stabilizing brace should make the firearm compliant and fall under that option, as in removing it and removing the rear surface area.
And if someone has questions about their specific item, they can email that to you, right?
Yes, ma'am.
fire_tech@atf.gov. Next question, will the registration classify the pistol as an SBR from that point forward?
That's how you're registering it. You're registering this as SBR. So yes, it's an SBR.
Okay. All right, hang on 1 second. We're getting some more questions.
Answer anyone ever.
Okay, next question. As of today, can a customer buy a lower and a pistol brace in the same transaction?
So what you're talking about, and we've had this discussion with a lot of various people have put this in, is the concept of constructive possession. Can you sell them an AR pistol and an arm brace in the same transaction? Typically, this is going to be considered just an SBR that's broken down. You can't pull them apart and hand them both pieces. That would be the transfer of an SBR. However, we want to be very careful here, and constructive possession is extremely fact-driven. And you typically have to look at many of the facts in order to determine whether or not there is constructive possession of a short-barreled rifle. For example, there may be an FFL who sells barrels of all lengths, AR receivers, stocks of all shapes and sizes, arm braces, and they're all on the shelf. That wouldn't necessarily indicate that the person's in possession of the FFL's in possession of SBRs. It just indicates that the person sells these parts. However, if you have an individual who has one pistol and an arm brace that they have slid off of it and laid next to the firearm, and that is all that they have, and there's no access or there's nothing else there, typically that's considered to be a short-barreled rifle because they are in dominion and control over those two parts, and it can only be assembled to be a short-barreled rifle. But again, those are the extremes. So what we don't want to do is get into a back and forth about what if this and what if that. What we're saying is typically the transfer of both the SBR, both the AR pistol along with the arm brace typically constitutes the transfer of an SBR. But again, it depends on the facts, and we want to be very careful of that.
All right, so along those lines, can we still sell packaged braces that are not attached to a firearm?
Of course, they're parts. You can sell parts.
All right, another question about markings. Do individuals have to engrave receivers with name, city, and state, or do existing markings from original manufacturers suffice? So yes, we answered this a little while ago. The existing markings do suffice. So as long as your firearm that you are registering has all the required markings, manufacturer, the model, the caliber, if those things exist, city and state in which where the firearm was manufactured, if all of that is on there, you are in compliance. You do not need to add any markings to the firearm. Next question, what constitutes a permanent removal of the brace? My customers have a screw attached brace to a round buffer tube. Also, if they have an adjustable brace, can they simply remove the brace, or do they need to replace the buffer tube with a pistol tube that does not have the locking brace?
So we covered this a little earlier. Just the removal of the brace is in it itself enough. The issue becomes what we just talked about with constructive possession. So the brace itself does not need to be destroyed. It simply can't be taken off and stored in the same dresser drawer as the pistol, because then you have your constructive possession. So yes, you could take one that has an adjustable and put a round tube on and then have the brace right there, because it cannot easily go back on. But no, you do not necessarily need to do that. You just, again, need to consider it like any other normal shoulder stock, where you wouldn't just pull it off of a short barrel rifle and not think that it can constitute a constructive possession.
Okay, next question. What actions are currently being taken to improve the stability of the eForms website? Ever since this ruling was announced, the site has crashed many times, causing us to be unable to access the site to file Form 4 paperwork.
So we've recently been doing some testing on the site, which may be what you experienced, is the site would go down for a few moments while we rebooted, so that we can increase the level of people, the volume of people that are accessing the system right now. And we also have the direct path for the Form 1 people that are submitting that rather over somebody who is just their normal course of business, Form 2, Form 3, Form 5. They have the standard login, so we have those also.
Thank you. Okay, next question. If you are a Type 07 manufacturer, but not an SOT, and possess pistol brace firearms, what is the process to register? So the process for you is also an eForm 1. You can submit each firearm that you want to register on the eForm 1. Again, you are not subject to the $200 making tax. And to be clear, if you want to begin engaging in the business as a dealer of NFA items, you would have to get the appropriate SOT for that. But you don't need that simply to register these items and sell just those items. So what you have registered. Okay, next question. What if a firearm does not come with the brace? How does that affect what forms need to be filled out when transferring that firearm? I think we're a little confused at this question. So if this was your question, you can resubmit it. But if the firearm does not have a stabilizing brace on it, it isn't affected by this rule.
And it should be noted, you can only register under the tax exempt provisions of this 120 days if you currently possess a firearm equipped with a stabilizing brace, which would be deemed to be a short-barreled rifle under the new regulation. This is not an invitation for people to register firearms, AR lowers or AR pistols as SBRs tax-free. You make that assertion or you make it clear under penalties of perjury that you possess those at the time you're doing this tax exempt registration.
Okay, next question. Are we able to keep the mil-spec 6-position buffer tube, no brace or rearward attachments, or do we need to convert to a smooth buffer tube that will not accept any stock?
No, I believe it's been answered a couple of times that the The adjustable buffer tubes that you're speaking of are fine. Again, it's still part of the cycle of operations. No matter which tube you have on there, it's when we get outside of what's necessary for that. But you can keep that on there. You don't need a pistol buffer tube.
Okay, next question. When will the experts start answering emails sent to Ask the Experts?
We have about 7,000 emails over there right now. We are all working as hard as we can to get that done. So we're working on it.
Yep, thank you. Okay, next question. What about complete pistol lowers that were purchased that way without any upper or barrel?
Then no, they can't be registered. In order to fall under this final rule, it has to be a complete firearm with a rifled barrel already attached.
This is a follow-up question on the FFL that is a manufacturer but not licensed as an SOT manufacturer. They're asking how can they transfer those items once they register them. I think we just answered that a minute ago, but again, you can register these items on the E-Form 1 and you can go ahead and transfer them. You would have to transfer them on approved NFA paperwork, so a Form 4 if you're transferring it to a customer, but we are not requiring you to get a SOT dealer license unless you are going to become engaged in the business. It's going to be a regular course of business. It's not just selling off these particular items that you registered. Next question, do we have requirements as a coder of individual brace components? I think whoever submitted that question, if you can add a little bit more detail, we're not sure what you're asking, or again, you can submit that question to us via email with a little bit more information and we will get an answer to you. All right, next question. How about states that have different regulation and considered other, like the state of Connecticut?
Right, so we're aware that Connecticut has an issue with these. They're limited options for you. NFA branch would be unable to approve a Form 1 for an SVR in this situation because I believe, again, I'm not commenting on Connecticut state law. You're going to have to check with them, but it's our understanding that they in fact do not allow for these SVRs to be registered. Also, I am being told that if you remove the pistol brace, it puts them into a category that is prohibited as well under Connecticut law. You're going to have to comply with state law, and that's up to you in the state of Connecticut. So it may be that your only option is going to be to remove the arm brace and transfer it immediately out of state if state law permits that to an FFL out of state as an AR pistol if we're dealing with the ARs. Your options are limited. I mean, there are options available to you. You can destroy the firearm. You can turn it into ATF. I don't think you're going to be able to register it on a Form 1. That is my understanding, but you should check with Connecticut to confirm that. And then some of your other options are probably limited as well. You want to consult with Connecticut to find out what your options are with those particular firearms.
Yep, and that goes for all states. If you have questions about your own state laws, you'll need to contact your state to find out what your options are. All right, next question. If a registration is denied, will the registrant still have the recourse of converting the firearm to a 16-inch rifle or removing the brace? So again, that is one of the options is removing the brace or adding the 16-inch rifle. That can obviously be done whether you attempt to register it or not. Obviously, if the registration is denied because you are prohibited from possessing firearms, then at that point you cannot convert the firearm. You would have to turn the firearm in. All right. So we're scrolling through some of the questions now so we don't keep repeating the same questions. The next question, we were told at SHOT, I think they're referring to SHOT Show, that separate NFA approval workflow would be set up to account for this. How are you going to differentiate between SBRs that are registered due to this rule versus SBRs that an individual is registering not related to this rule? For example, consumer buys a 9-inch barrel for their current rifle with a standard stock and submits Form 1 to register the SBR. How does ATF know that it has or does not have the arm brace? Alternatively stated, how does ATF know whether the Form 1 is taxable?
The form was amended to reflect the tax forbearance. So that is how we know the difference between the tax paid Form 1 and the tax forbearance submissions.
You choose on the form what it is. You indicate to NFA whether or not you're registering a Form 1 tax paid $200 or whether or not you have an arm brace equipped firearm that you're registering under this 120-day forbearance.
Okay, next question. Can a user remove the brace but keep the support arm? Not the tube on an AR, but the arm that connects from the pistol to the brace, like a SIG MPX.
We'd have to get more information, what brace you're talking about. That support arm by itself may or may not provide that rear surface area. It probably is not integral to the cycle of operations. So we need a little more information to accurately answer that question.
Again, you can send that question to fire_tech@atf.gov. All right, next question. If we receive ARs with braces in the coming days, can we take off the brace and transfer the AR pistol to the customer without the brace? Yes, you can. That is one of the 5 options. Next question, will a person who submitted their Form 1 prior to today be denied because they did not pay the $200 for the tax stamp?
What was the question again?
Will a person who submitted their Form 1 prior to today be denied because they did not pay the $200 for the tax stamp?
No.
Next question. For submission of Form 1, should sole proprietor FFLs add their EIN or leave it off? Specifically, an FFL with brace firearms that are not on A&D but part of a personal collection. Basically, leave the EIN off or put it on.
Registering it as an individual?
Yeah, so if you're registering it as an individual, how would they do that? Just not an FFL, they're registering as an.
They don't need to add their
No.
EIN.
Right, but if they're registering it as part of their FFL inventory, then they
Yes,
would
yes.
include their EIN.
Yes.
So if it is your personal firearm, not part of your FFL inventory, then you're registering it as an private individual, not an FFL, therefore no EIN. Next question, how does this affect legally registered AOWs that would now constitute SBRs?
They would be misregistered and they need to be corrected in the NFRTR to reflect that they're SBRs.
Next question, has this ruling changed regarding the original statement about imported pistols?
So I think this is a 922R question. People were concerned about whether or not they could possess these firearms. If you have a firearm that was imported and you want to register it on a Form 1 tax exempt, you may do that. You can go ahead and do that. You do not have to surrender the firearm. You're permitted to do that as well.
After registration, can the brace be changed to a standard stock?
Yes, after you've got the notification back from us, then yes, we're saying that this stabilizing brace or a buttstock, we're saying that it provides surface area. So if it's an accessory or anything that would provide rear surface area, it's a shoulder firing device. It doesn't matter whether or not it's the stabilizing brace or a manufactured stock.
Okay, next question. Where do devices such as MCKs, where they have attached stabilizing devices, fall into this ruling? Does that device need to be registered?
Yeah, you're talking about CAA Roni kit, the micro carbine kit or conversion kit. They would need to be registered as they are very similar to the stock versions. There's another question, I'll go ahead and jump, that was put on there about how do we register this. You would be registering just like the AR, the receiver, and the serial number off of the Glock or the other standard size handgun that goes into the kit, but it must be registered as a full firearm inside of the kit. In other words, you cannot just, we touched on it earlier, register every Glock 19 or fire control unit as an SBR unless it's configured in accordance to what was laid out in the final rule.
Okay, next question. For military members currently deployed or stationed away from home and cannot currently complete the Form 2, can they get an extension from the 120-day limit. So again, individuals that currently possess these, they have to register, if they want to register, or if that's the option that they're choosing, they would have to do it on the E-Form 1, and there is no extension. It's compliance date is May 31st, so they have to submit. It does not have to be processed, but they have to submit the E-Form 1 by May 31st. Keep in mind, there are those other options that we talked about as well. Next question, a Remington TAC 13 or TAC 14 with a stabilizing brace attached, does this fall into the same rules as the SBR?
So the final rule covers rifles. It amended the regulatory definition of rifles. However, it does make some footnotes on there describing why stabilizing brace should not be used with smoothbore firearms, which will likely fall into one of two NFA categories, either short barrel shotguns or any other weapons. Again, we can't make a determinative classification based on this, but the final rule does not affect them. However, it clearly lays out what these firearms are classified as based on the features.
And furthermore, some of the classification letters that were out there, it specifically rescinds those as it applies to some of these weapons or firearms, considered firearms, these smoothbore weapons that were sold with attached stabilizing braces, and it makes clear that those classifications have been rescinded.
Okay, the next question, if we could give some clarification on destruction of the stabilizing brace. We're saying that one of the options is to remove the stabilizing brace, but you don't have to destroy the brace, correct?
That is correct. Again, we're talking that if you do not destroy it, and it would be in constructive possession with just your pistol type, that you don't have any other rifle there, no other necessity for that shouldering device, then at that point it would have to be destroyed. If not, it would be constructive possession.
Okay, next question. This just says by class 1 importer, do you mean class 10 importer? So again, to clarify, the options that we went over are for unlicensed persons, what they can do with their item that is now classified as an SBR, and then FFLs that do not have a class 1 or a class 2 SOT. So the class 1 SOT would be an importer of NFA items. A class 2 would be a manufacturer of NFA items. That's what we are talking about here. Class 1 or class 2 SOT holders, for their registration, it is through an E-Form 2. That's the difference. FFLs that do not have an SOT are registering their items on an E-Form 1. Okay, stand by. We're running through some more questions. Okay, next question. What options are available to individuals using stabilizing braces due to medical disability?
So the NFA doesn't have an exemption for use of a stabilizing brace for a disability. If it is configured as an NFA firearm, it must be registered. Now, again, you can register during this 120-day period tax-free. However, you can't be exempted from registration requirements under the National Firearms Act due to a disability.
Okay, the next question deals with trusts. Of all the trusts I've looked at, none required a notarization of assignment of property to a trust. However, language in the E-Form site suggests that notarization of the assignment of property is required for proof. Can you please clarify this?
I'm not sure that it says that notarization is required. I think it says that it's required that you show documentation that the firearm was part of the trust property prior to the effective date. That's a lot different than notarization. So as long as you're complying with what your state requires for purposes of listing property under the trust, then that's going to be sufficient if it shows the date on which that property was assigned. You're going to have to show that it was assigned to the trust beforehand. The reason behind that's quite simple. If you currently possess a firearm and decide that you would like it to be held by your trust, the trust doesn't currently possess it. And now, given the fact that today is the effective date, you're not going to be able to make the transfer to the trust and then have the trust register it on a tax-exempt form. What you would have to do in that situation is you would register it to yourself because you are the current possessor of it, not the trust. And then you would do a Form 4 tax paid transfer into the trust, and then it could be maintained or held by the trust after that period.
Okay, next question. Will customers need to submit photographs of the shoulder brace equipped firearm when submitting a Form 1? Can you explain what images are needed and tell us if images for standard Form 1s will be required going forward?
There are no images that are required. On the Form 1, we do recommend that you put a close-up image of the markings that are on the firearm, but there is no requirement.
All right, next question. If someone had a lower on hand and want to build a pistol / SBR, what form does he use?
A tax paid Form 1.
Yeah, so again, to clarify, so what we're talking about here are pistols with an attached stabilizing brace, the options for the current possessors of those. And that it's as of today, what you are currently in possession of today. So this is not talking generally about short barrel rifles. This is solely talking about this type of firearm. Let's see. Next question. Braces themselves will still be legal just as a part as itself. Will I be able to sell them? I think the individual was asking, a brace by itself, not attached to anything, can they continue to sell them?
Yes, a brace is a part. ATF doesn't regulate those parts except for purposes of importation, which this doesn't apply to. So certainly you can have them, you can possess them, you can sell them, you can do whatever you want. The question is whether when they're attached to these rifles or constructively held with other firearms, weapons.
Okay, next question. Are we allowed micro conversion kits by themselves, just like the braces as parts without a firearm?
Yes, it's the exact same thing that was just described. Again, it's a part. We're not regulating that unless it be certain standards within importation. But yes, it's a part.
Okay, great, thank you. All right, so that is all of the questions. If we didn't read your exact question in the way you typed it out, it's because we got very similar questions. So we're trying to not be redundant and keep answering the exact same question. So we will hold there. If you didn't get your question answered today, again, I encourage you to come to one of the other 3 classes that we're going to have today at 2 o'clock, 2 Eastern, and then tomorrow at 10 a.m. Eastern and 2 p.m. Eastern. Again, if you have a specific question that we didn't get to today, or you have a specific scenario, you can send it to us at fipb@atf.gov. If you have a question on a particular firearm, you can send that to fire_tech@atf.gov. Again, I encourage you to go to our website. This exact PowerPoint is available on our website, as well as a list of frequently asked questions, which I think just about every single question that was on here today that you guys typed into the chat is in that FAQ. So please go to the website and hopefully you get all of your questions answered there. Thanks again, everybody, for taking the time out of your day. We really appreciate it.